Alex here with an event video on David Mahon versus Howard & Howard, a case involving a businessman's complaint against his former law firm and lawyer, Richard Newman, for legal malpractice stemming from intellectual property services rendered regarding specifically patent, copyright, and trademark applications. The firm moved for dismissal, citing the statute of limitations, or more specifically, a technicality on imputing a corporate agent's knowledge to its principal, or in this case specifically, the accused lawyer's knowledge of his own malfeasance against the plaintiff. District Court Judge James Crockett agreed, dismissing the case in its entirety, causing Mr. Mahon to file an appeal that he would ultimately win. The Supreme Court cited an exception to the rule, specifically that notice to a corporation's officer is not notice to the corporation itself when the officer acts against the interests of the corporation, using as an example another case where the agent was alleged to be a participant in the fraud against his own corporation. Because there remain questions of fact as to when Mr. Mahon became aware of the alleged incompetent handling of his intellectual property rights, the case was remanded back to the District Court. District Court Judge Jessica Peterson has allowed comprehensive electronic coverage of the proceedings, the first hearing of which was already recorded and will be published shortly. The plaintiffs are represented by Mark Hutchison and Todd Rawl. The defendants are represented by Nicholas Santoro and Jason Smith. You can keep up to date with our coverage schedule by visiting ournevadajudges.com, and you can post any questions you have down in the comments below, or you can send us an email at media@ournevadajudges.com.
All right, this is back before this court on a reversal and remand from the Supreme Court, wherein my predecessor dismissed a complaint in a legal malpractice action, finding that the complaint was barred by the statute of limitations. The Court of Appeals found that the District Court erred by imputing Newman's knowledge of his own malfeasance to the plaintiff Mahon, and there was a factual issue remaining as to when Mahon's malpractice claim accrued. Thus, the Supreme Court instructed this court to decide whether Mahon's claim was untimely, and if so, whether the claim may be tolled. So my understanding is we just need to be moving forward on this case. I believe the first thing that was done, the complaint was filed in 2018, and I don't believe that there's been an answer. I believe that the first response of pleading was a motion to dismiss. Is that accurate, counsel?
Yes, Your Honor. We filed an original motion to dismiss. The court granted an order for a more definite statement, and Mr. Prawl filed an amended complaint that led to our second motion to dismiss, and that ultimately led to the matter that started the appeal. So yes, Your Honor is correct. We would be filing a response to the complaint and then getting the case moving forward at that point.
So my inclination is we just need to get this moving forward. So you just need to do an answer, and then I'll bring you all back in for your Rule 16 conference, and then hopefully once we get some discovery done, it seems like at that juncture maybe it gets teed up for an evidentiary hearing or a motion for summary judgment. But at this juncture we just need to get the case moving forward. Is that everybody else's inclination?